Welcome everyone to the University of New Mexico Law and Mental Health series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, you can enter them in the Q&A box anytime you feel comfortable. Do know that we do hold those questions until the end, and oftentimes it's not possible for us to get to all of them. If you are pursuing continuing medical education credits through this talk, there will be a sign-in sheet that's posted in the chat box shortly. If you're pursuing APA continuing education credits, that link for the survey for your certificate will also be posted in the chat box, but closer to the end of the talk. So keep your eye on the chat box. Make sure you open the link before you close the webinar or otherwise bookmark it, and make sure you complete your survey and save the survey after you complete it, because we don't have access to those after the fact. If you missed last week's talk in the series, Dr. Sean Jumper's informative discussion of management and care of transgendered individuals incarceration is now available on our YouTube channel. The link for that will be posted in the chat box later. The recording for this week's talk should also be available on our YouTube page later this week, and the PowerPoint slides will be accessible for people that have registered for the series. As a heads up, next week we'll have a Q&A style session on malleability of memory with Beth Loftus and Jeff Younger. Getting back to this week, I'm very excited to introduce today's speaker, who will be discussing resentencing evaluations in the context of the Second Look movement. This is Dr. Anna Abate. Dr. Anna Abate earned her Ph.D. in clinical psychology with a forensic emphasis from Sam Houston State University in 2021. She completed her predoctoral internship at the University of North Carolina and her postdoctoral fellowship at the University of Virginia. Dr. Abate then joined North Carolina State University, where she currently serves as the Assistant Director of Research at the Center for Family and Community Engagement. In this role, she develops, obtains, and manages center grants and contracts, leads research and evaluation initiatives, and provides fiscal, programmatic, and administrative oversight on the center's research. Her research has been related to mental health, families, and justice-involved populations, and she also maintains a private practice specializing in forensic evaluation. She has a rich background in forensic evaluations, ranging from competency, sanity, violence risk, and pre-sentencing evaluations. So Dr. Abate, Anna, on behalf of the University of New Mexico, thank you so much for joining our series, and we're very excited for you sharing your expertise with us today. I'll go ahead and throw it over to you.
Awesome. Thank you so much. Thank you for that introduction. I am super excited to be here. I have been a chronic viewer of these series for many, many months now and have really gotten to learn a lot from others. So I'm excited to share on this topic. So I'm going to talk about conducting resentencing evaluations within the Second Look movement and talk a little about legal, developmental, and some ethical considerations. This topic, I think, is really cool, and it's really, I think, a good mesh for me personally, as it really combines a lot of my research interests, looking at juveniles, developmental psychology, families, mental health, justice-involved populations, as well as my clinical interests, looking at sort of that through that forensic lens. And even the Second Look movement wasn't something that I was super familiar with until I started doing a little bit more of a deeper dive into some of these evaluations. So I'm really excited to share with you all a bit about these and a bit about some of the history and the legal context for them. So I'm not going to dive into my bio, but it is in the slides in case anybody needs it again. Again, I'm Anna Abate, and I currently work at the North Carolina State University. And all right, here is some continuing education information. I think, as Dr. Perillo mentioned, you'll look in the chat for all of those links and all that great stuff. And then there will be an evaluation link at the very end. All right, just some disclosure. So I don't have any financial agreement related to the contents of this presentation. And here's sort of all the rest of that great disclosure information that's needed. All right, and then just a disclaimer. So the views expressed in this presentation are my own and do not necessarily represent the views, policies, and positions of the University of New Mexico. All right, so today we're going to hop into this topic and cover hopefully these 4 learning objectives. So first, we want to understand the key legal principles established by the Miller versus Alabama decision and some subsequent rulings, and how these principles impact the role of psychologists and other mental health professionals in resentencing evaluations. We want to identify the critical developmental and psychological factors that must be considered when evaluating a defendant for resentencing. We want to consider specific assessment techniques, approaches, and tools used to conduct resentencing evaluations. And then we want to analyze the ethical challenges and considerations psychologists and mental health professionals face when conducting resentencing evaluations. So I just want to make one disclaimer before I get more into the material. So this presentation is really intended as an overview of the process for conducting Miller and related second look movement resentencing evaluations. And it includes some key considerations relevant to this practice. So this really should not be considered any comprehensive training. And this information is really provided to introduce essential concepts and practices, but doesn't encompass the full depth required for conducting these evaluations. So I would say for individuals seeking to perform these types of resentencing evaluations professionally, it's really crucial to pursue additional specialized training and supervision, and consulting with experienced experts and obtaining some formal training is highly recommended to really ensure a thorough and proficiency in this complex area. All right, so let's dive into it. So we're going to go back to school for a brief second here. We're going to talk about some case law. So we're going to examine kind of two pivotal Supreme Court cases that have significantly impacted juvenile sentencing. First, I want to talk about Graham versus Florida, which was decided on May 17th of 2010. And this case involved Terrence Graham, who was sentenced to life without parole for a non-homicide offense. So specifically armed burglary and attempted robbery. And the Supreme Court ruled in this case that imposing a life sentence without the possibility of parole on a juvenile for a non-homicide offense violates the Eighth Amendment's prohibition against cruel and unusual punishment. And the court held that such sentences are unconstitutional for juveniles because they fail to account for the unique aspects of adolescent development and the potential for rehabilitation. So then following this, the Supreme Court addressed a similar but more severe issue in Miller versus Alabama on June 25th, 2012. So this case involved Evan Miller and Cuntrell Jackson, who were both sentenced to life without parole for homicide offenses. In this case, the court ruled that mandatory life sentences without the possibility of parole for juveniles convicted of homicide are unconstitutional unless an individualized sentencing hearing is conducted. And so this ruling really emphasized that judges must consider the juvenile's age, their background, and the nature of their crime before imposing such a severe sentence, which is ensuring that each case is evaluated with a focus on the juvenile's potential for rehabilitation. And then additionally, the case Montgomery versus Louisiana in 2016 clarified that Miller's ruling is fully retroactive. So what this means is that individuals who are sentenced to life without parole as juveniles prior to the Miller decision are now entitled to have their cases reviewed in light of new standards established by the court. So what did that leave? What was the status of juvenile lifers after these rulings? Well, as of 2017, approximately 2,100 to about 3,150 individuals, kind of depending on your source and where you're looking, were serving life sentences without the possibility of parole for crimes they committed as juveniles. And probably not surprising, but there are racial and ethnic disparities in the application of juvenile life without parole. So for example, African-American juveniles make up 23.2% of arrests for murders involving a white victim, but they receive 42.4% of juvenile life without parole sentences for these crimes. And this disparity is pretty stark when we compare this to white juveniles who, when convicted of an African-American, receive juvenile life without parole sentences at about half of that rate, 3.6% relative to their arrest proportion, 6.4%. And so these are things to keep in mind as we think about the status of juvenile lifers and those who are serving life without the possibility of parole when convicted of as a juvenile. So we still have a little bit more of case law. So one more, let's talk about Jones versus Mississippi. So this is a significant case that was decided by the Supreme Court on April 22nd, 2021. In this case, Brett Jones, who was convicted of a homicide offense as a juvenile, was sentenced to life without parole. And so the Supreme Court's ruling in this case upheld the sentence and determined that there is no constitutional requirement for a specific finding of permanently incorrigible before imposing a life sentence without parole on a juvenile. So this means that states have the discretion to impose life without parole based on their own legal standards and processes without needing to prove that the juvenile is incapable of rehabilitation. So this decision does not overturn the principles established in Miller versus Alabama, which requires individualized sentencing for juveniles. Instead, this case clarifies that while Miller established the need for individualized consideration, it does not mandate a specific finding of permanent incorrigibility before such sentences are opposed. And this ruling has implications for this ongoing debate about juvenile justice and rehabilitation, and really reflects the complexity of balancing the needs for justice and the potential for reform in juvenile sentencing. So what did that leave states to do, and what was the status of states kind of after all of these Supreme Court decisions? Well, following these different Supreme Court decisions and addressing juvenile life without parole, states have taken varied approaches in response. So prior to Miller versus Alabama, some states, including Alaska, Kansas, and Kentucky, had already prohibited juvenile life without parole. But then since Miller, there has been a notable legislative shift. So 25 additional states and the District of Columbia have enacted laws abolishing juvenile life without parole, which is starting to reflect a broader trend towards reforming juvenile sentencing practices. And in addition to these legislative changes, state Supreme Courts, like in Massachusetts, Iowa, and Washington state, have ruled that juvenile life without parole is unconstitutional under their respective state constitutions. And so these judicial decisions expand the protections afforded to juveniles, going beyond the federal requirements established by the Supreme Court. And overall, these responses really illustrate a significant movement towards eliminating juvenile life without parole and reevaluating juvenile sentencing policies in light of sort of evolving standards. So now let's connect the Supreme Court rulings with the ongoing trend known as the Second Look movement. And this movement really seeks to review and potentially modify long-term sentences. So this movement is really closely related to the principles established in Graham and Miller, and emphasizes the need for continued evaluation of sentences based on evolving understandings of justice and rehabilitation. The Second Look movement really started with ensuring compliance with the US Supreme Court's decision in Graham versus Florida and Miller versus Alabama on the constitutionality of juvenile life without parole sentences. However, following these cases, there was more of a call for states to adopt second look judicial sentence review processes. And so the Second Look movement has emerged as a response to the recognition that sentencing practices probably need to adapt to new insights about juvenile development and rehabilitation. And the decisions in Graham and Miller really highlighted the importance of individualized consideration in sentencing, which really set the foundation for this movement. And this movement represents a shift towards more flexible and perhaps humane sentencing practices. It advocates for mechanisms that allow for the reevaluation of sentences and providing opportunities for those serving long-term sentences to seek reconsideration in light of personal growth or changing legal standards. And in fact, recent developments show that many states are implementing laws to facilitate these reviews, like I mentioned. And this is beyond just responses to the Supreme Court cases. And all of this really reflects a broader trend towards aligning sentencing practices with our more contemporary values of justice and rehabilitation. And so in summary, the Second Look movement really builds on the legal precedent set by Graham and Miller and ensures that the justice system remains responsive to kind of new understandings of human development. And so from that movement, we have what we call Second Look laws. And Second Look laws are legal provisions that allow for the reevaluation of long-term prison sentences, providing opportunities for individuals to seek sentence reductions or modifications based on their behavior, their rehabilitation, or changes in circumstances. And these laws are a part of that broader movement aimed at ensuring that sentences reflect current standards of justice and the potential for personal growth. And so these Second Look laws provide this opportunity for reevaluation. So individuals serving long sentences can petition for a review of their sentences after a specified period of time. And this review assesses whether their continued incarceration aligns with our standards and their personal growth. These laws also tend to focus on rehabilitation and personal growth. They emphasize the individual's progress and behavior while incarcerated, evidence of rehabilitation. And the goal for these laws is to consider whether the individual has demonstrated significant change and growth that may warrant a reduction in their sentence. But they all have different eligibility criteria. So eligibility for a second look review typically depends on factors such as the length of time that the individual has served, the nature of the original offense, the individual's behavior while incarcerated. Some laws provide automatic reviews at specific intervals, so like every 15 years perhaps, while others allow for requests for review based on particular circumstances. And then some laws have like very specific age requirements, so that, for example, the offense must have been committed under the age of 18 or by the age of 18. But actually, more recently, these ages are expanding to include a time period of emerging adulthood up to about the age of 25. These laws also provide for a lot of judicial discretion. So the review process is usually conducted by a judge who evaluates the individual's case based on the established criteria. And then the judge has this discretion to decide whether to like reduce the sentence, grant parole, or take other actions consistent with the current legal standards. And there's been a lot of legislative and judicial response. So many states have enacted second look laws in response to these evolving views. And some, like I mentioned previously, state Supreme Courts have ruled that life sentences without parole for juveniles are unconstitutional, which is leading to the development of second look laws as a mechanism for then revisiting these cases. So ultimately, second look laws are part of a broader movement to address issues of fairness and justice in the criminal justice system, particularly for individuals who have shown significant personal reform and are serving perhaps disproportionately long sentences. All right. So what we have here is a map that I got from the sentencingproject.org. I have the link to the map if you want to check it out yourself on the slide. But this map I thought was a really great overview of the state level reforms and court decisions related to juvenile life without parole and other lengthy sentences for youth and emerging adults across the United States. So if we start and we look at like the green states, like the teal, green sort of colored states, these states such as California, Oregon, and Colorado have enacted laws that allow for a judicial second look at sentences. So this means that juveniles or emerging adults who are sentenced to life without parole or other lengthy sentences have an opportunity to have their cases reviewed after serving part of their sentence. Now, if we look at the dark gray states, so states like Illinois, Iowa, and Wyoming, they have had their state courts rule that certain lengthy sentences imposed on youth beyond just life without parole are unconstitutional. And so these rulings recognize the need for leniency and, again, that potential for rehabilitation for younger offenders. And then if we look at the red states, so Washington State and Michigan, these states have seen their courts rule that life without parole sentences for emerging adults, so now we're thinking of between the ages of 18 to 25, are unconstitutional. And so this acknowledges the continuing development and potential for change in this age group, similar to considerations for younger juveniles. So one thing to particularly note about this map is that it doesn't include sentence review opportunities that are limited to a short time after sentencing, or to those that apply retroactively to like specific reforms and those sorts of things. All right, let's dive a little bit into some examples. So in this slide, we're going to look at specific examples of states that have implemented second look laws. Again, this is just like a quick look at a few examples of this. And these laws provide opportunities for individuals who are sentenced as juveniles to have their sentences reviewed after serving a significant portion of time. So for example, we have California, and California has been a pioneer with its Fair Sentencing for Youth Act, allowing resentencing for juveniles serving life without parole. Oregon followed suit with very similar provisions under their Senate Bill 1008. Washington, D.C. also enacted a Second Look Amendment Act in 2019, again, reflecting the growing trend towards reconsidering lengthy sentences imposed on juveniles. And then Colorado established a juvenile clemency board under House Bill 1287, further illustrating the national shift towards more lenient sentencing and the possibility of rehabilitation. So again, this legislative trend highlights a broader recognition of the developmental differences between juveniles and adults and the potential for change and rehabilitation in younger offenders. And again, this is just a quick look at a few examples of these cases and a few examples of these laws in different jurisdictions. But there's, as we kind of saw, there's many others across the United States. So let's talk a little bit now about these evaluations. So as a result of these laws and court cases, we as mental health professionals may be asked to conduct an evaluation to help the court determine the appropriateness of long-term sentences. So in particular, oftentimes our training in developmental psychology, expertise in assessment, and ability to apply this knowledge impartially and effectively makes us pretty uniquely suited to conduct both these second look evaluations and Miller evaluations. And these evaluations really require deep psychological insight and the ability to interpret complex human behaviors. So these are all capacities that the courts may ask behavioral health professionals to tackle. And so we're going to take a look at two types of evaluations that are used in the criminal justice system in this context: second look reevaluations and Miller evaluations. So while both of these evaluations aim to assess the appropriateness of long-term sentences, they do serve different contexts and different purposes and are used again in distinct contexts. So starting with second look evaluations are conducted after a defendant has served a significant portion of their sentence. The focus here is on the individual's behavior during incarceration, any rehabilitation that they have undergone, and their readiness to reintegrate into society. And then these evaluations can lead to sentence modifications. Now, on the other hand, Miller evaluations are specific to juvenile offenders facing life without parole. So these evaluations are required to consider factors like the juvenile's age, the juvenile's maturity, family dynamics, and role in the crime at the time of sentencing. And the goal here is to ensure that the sentence is proportionate to the individual circumstances, potentially avoiding overly harsh penalties like life without parole. And so while both evaluations consider the potential for rehabilitation, second look evaluations generally focus on changes after sentencing, and Miller evaluations tend to address circumstances at the time of the crime. However, you will really have to review the specific law in your state or jurisdiction, as many second look laws also consider childhood circumstances and the time of the offense. So overall, both evaluations play crucial roles in ensuring that sentences not only match the crime, but also the individual's potential to change in current state. All right, so now we'll dive a little bit deeper into the factors that go into a Miller decision and resentencing decisions as a part of this second look movement and legislation. So in discussing juvenile sentencing, it's essential to consider the Miller factors that were outlined in that Supreme Court case, right? Miller versus Alabama. And these factors guide us in assessing each juvenile's unique situation, as was required by that Supreme Court case. So some of the factors include, right, developmental immaturity. So we want to look at the juvenile's impulsiveness, their grasp of consequences, all of which are crucial at a developmental stage when risk-taking is a lot more common. We also want to take into consideration family and home environment. So the impact of a troubled home life, including like abuse or neglect, which can significantly influence behavior and decision-making. And it's important to consider these factors. We also need to consider the circumstances at the time of the offense. So understanding the juvenile's actual involvement, so what was their role, what were they doing, and any peer or adult influence is really key to fair sentencing and is really important when in these evaluations and in the sentencing decisions. We also need to consider their capacity for change. So young offenders have a high potential for rehabilitation, and that's a really critical factor in determining appropriate sentencing. We also want to take a look at those external influences. So this is like the role of community and peers, which can shape behavior, which necessitates a look beyond just the individual, right? Looking at their surroundings, their community, who they're with, and what's available to them. And then, of course, mental health. So addressing any underlying psychological issue is vital to understanding the context of the offense and the appropriate response. So all of these considerations ensure that sentencing not only fits the crime, but then also aligns with that potential for positive change in a young person's life. All right, so now we're going to take a look at one specific example of a second look movement legislation and the factors that go into that. And this way you can kind of get a sense of the differences and similarities between Miller evaluations and these second look movement type evaluations. So specifically, this is the Incarceration Reduction Amendment Act, or IRA, out of Washington, D.C. So I'm going to use this specific legislation as an example because I have the most experience conducting these types of evaluations in this jurisdiction. But of course, as I mentioned, be sure to look at the legislation in your jurisdiction if you're interested in doing these evaluations, as they probably have different wording and some maybe other different factors. But I think broadly, you'll see a lot of overlap with these. So IRA in particular was designed to provide individuals sentenced as juveniles to long prison terms the opportunity to petition for a sentence reconsideration. So in 2017, the DC Council passed the Incarceration Reduction Amendment Act, or IRA, which allows those convicted as very young adults to petition for a modification to lengthy sentences. And so the law seeks to consider the defendant's personal history, commitment to change, rehabilitation of prison, their statements from victims and prosecutors, in deciding whether the petitioner's sentence should be modified. And so this legislation was then followed by the Second Look Amendment Act of 2019, which became law in April of 2021. Oops. Okay, I think we're good. Yeah. So eligibility for IRA is restricted to those who are convicted as juveniles. Originally, this law was written so that it was those who were originally convicted up to the age 18, and it has more recently expanded to cover the age up to 25. And they need to have already served at least 15 years of their sentence. So again, different jurisdictions may have different requirements and different age ranges and different timelines for sentences that they need to have served. So this one in particular, this law states that the court shall consider the defendant's age at the time of the offense, the history and characteristics of the defendant. You need to look at their behavioral record. So the law says that the individual's conduct during incarceration is closely scrutinized, with an emphasis on positive behavior and any disciplinary issues. This law also wants to know whether the defendant has demonstrated maturity, rehabilitation, and a fitness to re-enter society that's sufficient to justify a sentence reduction. And so this would mean looking at things like active participation in educational or vocational training programs or any other rehabilitation initiatives. The defendant's family and community circumstances at the time of the offense, including any history of abuse or trauma or involvement of the child welfare system, is really considered, and the extent of the defendant's role in the offense and whether and to what extent any other people were involved, peers, adults, and those sorts of things. And then this one, this law in particular really talks about this diminished culpability of juveniles and persons under the age of 25 as compared to that of older adults. And it talks about how there's these hallmark features of youth, which include immaturity and a failure to appreciate risks and consequences. And the law specifically states that counsels against sentencing them to lengthy terms in prison, despite the brutality or cold-blooded nature of any particular crime. And it needs to consider, the law says we need to consider the defendant's personal circumstances that support an aging out of crime. So again, this is just one example of specific legislation in one jurisdiction of these second look movement legislation and laws. All right, so let's delve more into this crucial role of evaluators in conducting these resentencing evaluations. So again, these evaluations are fundamental in providing the courts with essential psychological insights that influence resentencing decisions, especially under laws such as IRA and following landmark cases like Miller versus Alabama. Again, I want to preface that this is a broad overview. Different jurisdictions include different factors for resentencing, so it's really important to make sure that you understand what's included in your jurisdiction. But I think that, again, this should be a relatively general and include many of the factors that many locations and jurisdictions do consider. And so the primary objective here is to provide a detailed psychological evaluation that assesses the defendant's rehabilitation efforts, risk of reoffending, and readiness for reintegration. So this really involves a deep dive into the defendant's progress in any institutional programs and their psychological development during their time served. And risk assessment is a big cornerstone of these evaluations. It's not just about whether the defendant might commit a crime again, but also understanding the nuanced ways in which they have responded to rehabilitation efforts and how they've adapted to institutional life. And this is really crucial for helping to determine their suitability for reintegration into society. Another really important aspect is the impact of incarceration on the defendant's psychological state. So long-term incarceration can have profound effects, and it's really imperative to understand that and evaluate both the challenges and the psychological growth that may have incurred while this individual was imprisoned. We also want to provide the courts with detailed insights that ensure their decisions are really informed by the latest psychological information. So this includes taking into account the defendant's developmental changes since their initial sentencing and incorporating research to help explain that to the courts. And I'll dive into a little bit more about that in a little bit. And then lastly, we consider the influence of the environment on the defendant's behavior and development. So this includes, again, that effectiveness of any educational programs and their readiness for integration. All right, so I'm going to dive into each one of these factors a little bit more and kind of talk about the things that you can use to help assess for these pieces and what this would look like for these evaluations. So evaluators really need to assess whether a defendant has actively participated in rehabilitation programs such as therapy, education, vocational training. So this part of the evaluation would really look at tangible achievements like certifications, educational degrees, which are really indicative of a defendant's commitment to personal growth and how they've been spending their time. Moreover, changes in their attitudes or behavior towards crime are critical to kind of gauge some genuine rehabilitation. And this assessment really helps the court determine if a defendant has made substantial efforts towards reform, which would be crucial for the court's decision in considering sentence modification. All right, like I mentioned, a risk assessment is a big cornerstone of these types of evaluations. And this really aims to estimate the likelihood of a defendant reoffending. So this involves the use of psychological assessments designed to predict future behaviors. We want to review the defendant's adherence to institutional rules, involvement in incidents, and overall behavior. And what I think is really important about this part of it is we want to provide context to that behavior, especially within the scope of risk. So I think that's really important with this part of the evaluation is, again, to provide that context and to the court. Risk assessment in the context of juvenile resentencing requires a pretty nuanced approach, right? So the prevailing assumption, which is supported by research, is that most juveniles will naturally desist from criminal activity over time, which is a concept known as life course desistance. However, there is that small set of juveniles identified as life course persistent offenders who may continue offending into adulthood. And so what we want to do as forensic mental health professionals is to evaluate whether a juvenile or former juvenile falls into this persistent category or whether they're amenable to treatment and rehabilitation. And again, like I was saying, we really want to be able to provide some context to their behaviors, especially any incidents that they received. So it's going to be really important for this part of the evaluation to review their disciplinary record from the institution and provide some context potentially to any incidents that occurred when necessary. So for example, in one case where I did an evaluation, second look type evaluation or an IRA evaluation, I had a defendant who had gone almost 20 years without a single incident while housed in the BOP. And then more recently, he had an incident where he broke a piece of his property. And so he received an incident report for that, for not listening to the correction officer and being disobedient. And so it was really important to put that example into context, to really put that example into this larger context of risk, right? And to explain how that was or was not indicative of a larger behavioral pattern of aggression or violence. So one example that you may include in your report, depending upon your situation, is like, this incident suggests or does not suggest a pattern of aggression or violence or a lack of behavioral control, and being able to contextualize these incidents in this risk assessment piece. And so being able to provide a multifaceted approach provides this court with a really nuanced understanding of the defendant's potential risk to society. All right, you also want to evaluate potential for reintegration. So this function evaluates the defendant's readiness to return to and positively integrate into community life. So key considerations include the offender's social skills, the robustness of their support networks, and their post-release plans, which should really cover stable housing and employment prospects. And so this assessment really ensures that the offender is not only ready to leave the prison environment, but is also prepared to contribute positively to society, and all of which helps reduce the likelihood of recidivism. And so for this component, you really want to look at statements from family, from friends, letters of support, and what are the defendant's plans for release? Should that be a consideration if the individual is looking for like a significant reduction and then potential release? What are their plans? Where are they going to go? Where are they going to work? Do they have support? Do they have a very firm plan? And that's going to be really important for this component of the evaluation. All right, you also want to look at, right, the impact of incarceration. So this is to assess how much time was spent in prison has affected the defendant's psychological health. We want to look at any long-term psychological effects, the mental health interventions received, and the defendant's resilience. Understanding these aspects is really important for evaluating whether continued incarceration is beneficial or if they may be better served by alternative sentencing that supports continued rehabilitation in a less restrictive environment. So just really understanding the treatment and interventions that they received and how their time was spent in incarceration and how that went. And again, keeping that in context too, right? It can be helpful to have experts on, for example, the BOP, be able to provide some context to what life is like in that environment. All right, so as we mentioned, it's going to be really crucial to note any developmental change in context. So it's really crucial to not only assess how much a defendant has matured since their sentencing, but also to contextualize their developmental stage at the time of the offense. So again, this is a two-part sort of piece here. So this all involves a deep dive into the psychological and emotional growth of the defendant and how they've experienced that and how they've grown during their time in custody. So we want to evaluate, again, changes in their maturity, changes in their perspective, and all of that could kind of indicate this rehabilitation, how they've been spending their time, activities that they've been engaged in, treatment that they've been seeking, those sorts of things. And we also place a significant emphasis on providing developmental context to the offense itself. So I think about this a little bit like a mitigation evaluation. And so this really means understanding the psychological and developmental factors at play during the time of the offense. This might have influenced the defendant's capabilities and choices. And so again, we want to provide that context for the court and be able to kind of describe what was going on for the defendant at that time and things that we should really be considering. By assessing these aspects, the court can then better discern whether the original sentence is still appropriate or if adjustments are necessary to account for both the defendant's growth and sort of that developmental context at the time of the offense. All right, so I'm going to dive a little bit more into what this developmental context looks like, especially when we're thinking about the circumstances of the offense and the time of the offense. So again, that developmental piece, we want to think about their developmental trajectory and how they've grown and developed. And we also want to think about their developmental period at the time of the offense. So developmental immaturity, right? So we begin by assessing the juvenile's age-related characteristics. Young offenders often display impulsiveness, poor understanding of consequences, and that should be weighed. We want to consider the circumstances of the offense. So the specifics of the crime itself also demand a lot of attention. It's really crucial to understand their role in the offense, including any coercion or influence by adults or peers, which might mitigate their culpability. And then finally, we want to look at external influences that might have shaped their actions. So this, again, can include those peer dynamics, community resources or lack thereof, and educational opportunities, or again, lack thereof. So all of these factors should also be considered when we're thinking about a juvenile at the time and the circumstances at the time of the offense. All right, now finally, we want to broaden our focus to include not only the prison environment and the juvenile themselves or the former juvenile themselves, but also the conditions and influences from the defendant's early life. So this is even beyond just the circumstances of the offense itself. And so this comprehensive approach, again, helps the court understand the full spectrum of environmental factors that might have shaped the defendant's behavior. So we want to assess the impact of institutional programs. So this is looking at how the defendant has engaged with educational and therapeutic interventions available and how these interventions may have supported any rehabilitation. We want to examine social dynamics and how, especially maybe within the prison context, we want to talk about the early life conditions of the defendant. So understanding the family dynamics, community environment, educational opportunities can all provide really significant insights into why the defendant may have engaged in criminal behavior initially. Again, this is kind of similar to when we think about like a mitigation evaluation. These early environmental influences are really crucial for contextualizing the defendant's actions and also helping the court understand their developmental trajectory. Like how did this individual maybe get to this point? And let's really provide a lot of background and context and understanding to that. And finally, we want to evaluate how well the defendant has adapted to institutional life. So this includes their ability to navigate and adapt to the structured environment of the prison, which again is indicative of a potential to reintegrate into society successfully. So altogether, by considering both current and early environmental influences, we can ensure a more holistic view is taken during resentencing evaluations. And this approach not only informs the potential for rehabilitation, but also aids the court in making more equitable decisions regarding maybe their future. All right, so let's dive into kind of like the actual assessment process, like how someone might do this. So of course, the process really begins with an initial review. So we're going to examine the defendant's complete case history, including details from the original sentencing and any significant legal or behavioral developments since then. Right, we want to take a look at prison records, their disciplinary report, how they've been spending their time, any motions to reconsider or reduce the sentence, and the court's response. That's really helpful to know what has been the issues that the court has been seeing, if these have been, if this is not the first time that a defendant is trying to get their sentence reconsidered or reduced. And so those can be really helpful when you're starting the evaluation process. So of course, then we've got interviews are conducted, not just with the defendant, but also with perhaps correctional staff, get a sense of how the defendant has been doing in an institutional setting, with family members or others who have significant interactions with the defendant, with those who may be able to help and provide housing or employment opportunities. And so these interviews are really essential for understanding their behavior from multiple perspectives. And then any psychological testing, right? So if we're using standardized tools, this may include the use of like risk assessment tools, right? Because that's a really big part of these evaluations. Like the HCR20 is a great example of one that you can use in these evaluations when we're thinking about more standardized testing. We need behavioral observations. So again, looking at all of those records. And I think one of the major pieces of these evaluations, like many others and like mitigation reports as well, is collateral information, right? This is crucial. So we gather data from the defendant's participation in educational and vocational training programs, therapy sessions or other programming, any other peer support programming that they might be engaged in. And again, this provides this broader view of their engagement and their progress. All right, so here I'm just providing some kind of brief kind of sample report structure or some things that you may want to consider or think about if you're going to write these reports and what should be in them. So again, each section of this report is really crafted to provide a really holistic understanding of their background and their current circumstances to help inform the court's decision accurately. Right, we want to provide all of that really relevant background information. So all their personal and historical data, any relevant personal information, their basic demographics, family and developmental history, so their upbringing, family dynamics, any formative experiences, educational history, so their educational background, which can include highlighting achievements or challenges faced in educational settings, employment history, both within the institution and prior, social relationship history, so their social interactions, which can help really assess their support network and their social interaction or integration. Substance use history, medical history, mental health history, right? All of those things we typically include. Legal history. And then one section that I like to include is this adjustment and functioning during their incarceration. So this is like observations on how the defendant has adapted to the correctional environment, highlighting any like participation in programming, any notable incidents, again, providing context to those when relevant. And then of course, right, mental status and behavioral observations, our psychological testing, And then kind of the big piece of this is this evaluation under the relevant statute. So this section ties together the gathered information to specific legal standards. So again, I would kind of go through and kind of tie all of this information to those specific standards within your jurisdiction and what the legislation says. And this would help assess kind of that eligibility. And then finally, we have this conclusion. And so the conclusion really is a synthesis of all of the findings from the evaluation, all of that stuff put together. And one thing I want to really highlight is that this conclusion does not contain a specific answer regarding whether the defendant should receive a sentence reduction. Rather, this is a summary of the relevant factors and points and puts the information obtained in context. So again, this summarizes it and puts the information in context rather than saying, yes, this defendant should receive a sentence modification or a reduction, or no, this defendant shouldn't. That really is a decision for the court. We just want to provide all the information, really put it together, making sure that we're following what the legislative body says, and really kind of highlighting it in that sense. And so we want to make sure that this really helps the court to make well-informed decisions based on all of this information. Okay, so how do we synthesize this? What can we do? What all can we include? So incorporating research and putting the behaviors in context, I think, is going to be crucial for these evaluations. The goal is to create a well-structured report that not only presents data, but again, contextualizes it to enhance the understanding and support informed judicial decisions. So again, the first step is crafting these reports through a thorough contextual analysis. This involves integrating individual data points within the broader context of the defendant's life and criminal behavior. And by doing that, we provide the court with a nuanced view of the defendant's rehabilitation progress and current behavior, which illustrates how changes might support a resentencing decision. It's also really important to incorporate relevant research. We want to make sure that we're including the latest findings from psychological and criminological studies to support our conclusions. And this research adds depth to our assessments and links the defendant's behavior and treatment outcomes to well-documented trends and patterns in rehabilitation and recidivism. Remember, our role is really to educate the court and provide context, and I think incorporating research really does that. So for example, one really important area or vital area that can be included is just about recidivism rates. So including research on what factors most significantly impact the likelihood of reoffending can help contextualize the defendant's potential risk. So studies might focus on how age, type of crime, and specific rehabilitation programs influence recidivism, and it could be really helpful to incorporate those into your evaluation and into your report. And I've kind of put in the italics, I've put some statements that I have used in reports to how I kind of incorporate some of this research and then tie it in with what the defendant's particular, what's going on with that defendant in particular, and really linking those components together. Rehabilitation effectiveness, that's another great research area to include. So referencing studies evaluating success rates of different programs, such as any educational or vocational training programs. And so this research can substantiate claims about the effectiveness or lack thereof about these efforts. Developmental psychology, so including research about insights into how individuals mature from juveniles into adults can be extremely important. So research about understanding cognitive and emotional growth trajectories can really help explain the changes in the defendant's behavior and mindset, which is really important when we're thinking about young offenders. And then of course, you can include research about risk assessment validity and those pieces as well. So really by weaving this research into the evaluation report, we can provide a comprehensive, scientifically backed perspective that just aids the court in making informed decisions regarding resentencing. So this ensures that our findings are not only contextually relevant, but also aligned with proven correctional and psychological practices. And I think just really makes for a really strong, good evaluation. These reports, especially when we incorporate the research, can really help provide the judge and the courts with adequate context and help them make just well-informed decisions. All right, the last thing I want to touch on, because I know I'm running short on time and do want to allow a little bit of time for some questions, are ethical considerations, right? So of course, our typical ethical considerations should be noted, right? Confidentiality, informed consent, all of those pieces. But one of the few that I want to kind of highlight with these evaluations in particular is impartiality. So as evaluators, we're often hired with these evaluations by the defense. And so it's really imperative to maintain an objective stance throughout the process. And I think incorporating research components can help with that as well. And so this means conducting evaluations holistically, resisting any inclination to skew findings towards a narrative of social justice or advocacy. Again, our role is really to provide balanced and unbiased insights that aid in fair decision making and don't serve as advocates. And so that is kind of falls into my next piece here, is that we want to make sure that we are staying within this the advisory role, right? That we are providing the courts with the information and just providing that advisory role and providing them with information so that they can make the best decisions. It's also, again, really important to recognize the role of these, right? So they provide critical insights and data, but the ultimate decision regarding sentencing lies with the court. So again, the evaluator's role is advisory, which offering a professional opinion based on thorough assessment. And the evaluator's role is really to inform and educate, not to make determinations on sentence length and decisions about whether a defendant should be released or not, or what sort of maybe sentence modification they should receive. However, it's also important to consider that the impact of these evaluations can be significant, as they can influence legal outcomes by providing the court with detailed information on the defendant's progress, their risk, their suitability for reintegration. And so these evaluations can significantly impact legal outcomes and have the potential to alter decisions on sentencing, parole, or other legal judgments. So I think keeping all of these things in mind, in context, and doing our best to, again, maintain an unbiased perspective and to a thorough examination and evaluation, where we really incorporate all the pieces of data and put it into context for the courts, is going to be the best way to do these evaluations. So that was a lot of information. I threw a lot at you all, but I hope this gave a good overview of what second look evaluations and second look movement is. I've got some references here that will be included with the slides. A lot of these references relate to Miller evaluations, as there's not a ton out there on research specifically to like these second look movement evaluations, but I think we can all pull from these and help make these evaluations and really, useful things for the court. So thank you all. And here's this evaluation link and QR code. And I think we have a few minutes, barely.
All right. Well, thank you so much, Dr. Abate, Anna. What a, as you referenced here, what a little discussed area in particular. You can see from the number of questions we have people who are quite intrigued about the process, have a lot of questions about different options, different approaches here. We'll do what we can to get through some of them. Of course, it's not going to be possible to get to all of them that are already. And of course, though, audience, if you have additional questions for Dr. Abate, please feel free to enter them here. I will do my best to get through whatever we can here. The link for the APA Continuing Education Survey is in the chat box. If it's not working for you, make sure you bookmark that for later use and try it again in a different browser. A number of questions have related to just different questions people had in terms of what you might address or how you might address it in one of these kinds of reports. So one person asked, how would you address the lack of rehabilitative opportunities in prison? Do you account for that? This person adds, there's usually a wait list for education and employment, and prisons prioritize individuals with an out date. Do you address that?
Yeah, I think that's a really great point. And I have seen a lot of courts when a defendant has gone up for these resentencing and has requested for a resentencing motion, the courts have said, you haven't done enough programming. You haven't done enough programming. We don't see evidence of this programming. And I know a lot of defendants that say, I'm doing as much as I can get into because there are a lack of resources. And I think that is exactly where some of these evaluations and reports can come in to address some of that. I think speaking to the attorneys about potentially getting experts on prisons and maybe the particular prison, right? I mentioned the BOP. There are experts who can serve as like collateral sources to talk about BOP processes or other environmental processes or institutions. And I think getting some of that and incorporating it and saying, given the context, given, this person has been on this number of wait lists, they've been engaged in this number of things, and having maybe someone who can serve as an expert into those processes can help kind of talk a bit about that and again, provide that context. I know that comes up, it's a challenging one, and I do think that it can be a really helpful thing to include in our evaluations and reports.
Certainly, thank you for that. A couple people asked about the considerations of maturity, and somebody asked if you could address difficulty in measuring maturational development and decision making in like an institutional context.
Yeah, yeah, that's also a really great point, because if we think about some of these evaluations and these defendants, right, they're entering the system potentially when they're as young as 18, and so all of their development and then their growth is happening in an institutional setting from that time point forward. And so I think you have to look at sort of the behaviors. What are they engaging in? Are they engaging in treatment? Are they engaging in any educational programming? Can we talk about some of their development in that context, especially in a very unique and confined setting that is an institution? And bringing some of that in. And again, I think that's a great area too, to bring in some of those research pieces. Maybe I've seen examples where a defendant came in when he was really young, and then he served as like a mentor to other younger defendants as he got older. I think that's a great example of some development of that maturity. I know some defendants serve as like peer supports or suicide companions. And again, I think some of those things can speak to maturity. And I think just incorporating those pieces where you can and bringing in any research that's relevant would be really helpful to address some of that. I know it's tricky in these settings.
Yeah, and do you use any tests or recommend any tests about in a more formalized way of assessing developmental maturity or developmental immaturity?
I have not, so I don't know. I'm curious. There might be things out there that would help get at some of that, but I really tend to use behaviors, observations. We can often get maybe quotes from officers who have worked with these defendants for maybe an extensive period of time to talk about how they've been socially with other defendants or others that are in that prison setting. If they've served sort of like a peer or mentorship role, and can kind of get at some of that. So that's how I've generally done it.
Mhm. Get sticking on that kind of the decision to test front. You referenced the HCR20 different risk assessments. Somebody broadly, I think before you mentioned the HCR20, but just also wanted to ask like your thoughts about different types of risk assessment tools
Mhm.
available. No, there are so many different kinds and controversy regarding them. What are some of the challenges in picking out the best tool for in this particular contest, and which tools do
Yeah.
you find most relevant?
Yeah, that's a really great question. Some of these are hard because if we're thinking about risk, like the offense that these defendants are typically in for, right, occurred in a juvenile setting. So then we're thinking about risk as a juvenile, but they're not a juvenile anymore. And so that can make using risk tools kind of difficult. I think that HCR20 is generally perfectly acceptable to use in most cases. I think you'll have to use sort of your judgment when looking at that. I've also done these and evaluated risk without using a tool, and just sort of talking about examples of their behaviors, disciplinary record or lack thereof. Right, if you've got somebody who's been in a BOP setting for 20 years without a single disciplinary infraction, that's pretty good and not very common. So I think we can kind of talk about risk in that sense. And so I would have to look more. I haven't dug too much into kind of this, but there's been a lot of debate about, are these measures going to be useful when we're talking about juvenile offenders later on? But I think in general, I would say that HCR20 would be a pretty safe bet. But kind of, or not using an evaluation measure specifically. I don't think that's critical.
Do you have any gauge of roughly how common it is for people to use risk assessments in these kinds of evaluations?
I think it's pretty common, but again, it somewhat depends on the jurisdictions. I know that some courts, like, they need to have a firm risk assessment tool, and they really require that for these evaluations. And some jurisdictions are very open to just risk assessment more broadly. And so I know, like in Washington, D.C., it can really vary with our IRA cases, that sometimes we use them and sometimes we don't. Some judges say you didn't use any, that's a problem. Some say we don't care. So I think they're generally pretty common, but I think these evaluations are relatively newer and that we're still trying to get our footing. And so finding what's exactly going to be used every time is going to be challenging. And so I think using some, best clinical judgment and what's going to work for your case in particular.
Sure. Yeah, as we wrap up, since we are at the top of the hour, so several people asked about treatment opportunities and all that in general. I'll just throw one of the more
Yeah.
general kind of questions. Which rehabilitation treatment programs or reintegration programs do you find most effective in preventing recidivism? Do we know? What are some things to consider if we were adopting a program?
Yeah. When adopting a program, I think a lot of programs that are rooted in cognitive behavioral therapy are going to be really like beneficial and really helpful. And that's what a lot of the research says. I know sometimes too, I've seen cases where courts or parole boards will have issues with they'll say you didn't do, um, this certain treatment program, and they'll have an issue with if the defendant hasn't done a certain one. And so I think, but broadly, I think, being engaged in a variety of treatments, and I think it'll also depend on the defendant, right? If there's a history of significant trauma and the defendant has never engaged in any sort of trauma-based treatment or trauma-based therapy, that might be more of a red flag or a concern versus someone who maybe had significant substance use issues and has engaged in significant substance use treatment. So I think it's going to be kind of a variety of things that might be more dependent upon the individual.
Right. And as we wrap up here, one final question. Somebody asked in particular, or a couple of people had talked about people that have mental health needs in prison or that get transferred in particular. Are there considerations or relevance for people that have official mental health disabilities, particularly those that during their sentence were transferred from prison to a state hospital?
Yeah, that's a really great question. I think for that in particular, you're going to have to kind of again put that in the context of what is an environment that this individual is going to need. And if we're thinking about resentencing or a reduction in sentence, is their plan post-sentence going to be able to accommodate that? What treatment have they undergone? How consistent have they been with their treatment? What is their view of treatment? How well have they engaged? And are there things set up for them potentially outside, right? Are they going to stay in a hospital setting, or are they going to go to outpatient? How consistent will they be attending outpatient appointments, or how well will they be able to access treatment if they're going to be moving with their family in this certain area of this certain state? So I think all of those things are going to be really important to contextualize for these evaluations.
What a helpful and thorough discussion on a not really discussed evaluation, and a lot of core considerations that people could
Yeah,
do. Some people that aren't even involved in this audience that very well could foresee having an impact in this area. So,
right.
yeah, Dr. Abate, and thank you so much for that overview and sharing all of this really helpful information. As you can see from the continued rolling questions, a lot of engagement, a lot of thoughts, a lot of interest in this area, because it's often just not discussed, and there's a well opportunities available there. So thank you
Yes.
again for your discussion of this issue.
Well, thank you so much. Thank you so much for having me.
Yeah, and that wraps up this week's Law and Mental Health series. Next week we have Beth Loftus discussing legal issues in memory. We hope to see you then for another great discussion of issues of behavioral health in the law. Until next time.